is satisfied in the manner in which the ID parade was conducted. According to the Inspector Araman, who testified as PW28, the first accused person was satisfied that the parade was well conducted. However, it is notable that the first accused person did not sign on that form where he was supposed to sign to confirm that he was satisfied with the parade. Secondly, it is in evidence that PW7, and he admitted Owen, before he went to the identification parade, he had seen the photograph of the first accused person. And so that then must have aided and abetted him to quickly pick up the first accused person from the parade. Thirdly, whereas the officer who conducted this parade, who is Inspector Araman, says that the first accused person was not in a sling, contrary evidence has been given by the prosecution witnesses, including the protected witness. And so, the contradictions can only go to the benefit of the first accused person. And in just emphasizing on the need to conduct a proper identification parade and for the benefit of the office of the DPP, join me in the words of the court in David Mwitawanja and Others versus Republic. Quite good read on identification parade. And this is what the court parades ought to be conducted have been a subject of many decisions of this court over the years. And it is worrying that officers who are charged with the task of criminal investigation do not appear to get it right. As long as 1936, I don't know whether anyone of us was there, the predecessor of this court emphasized the value of identification as evidence and would depreciate considerably unless an identification parade was held with scrupulous fairness and in accordance with the instructions contained in the police force standing orders. They made reference to the case of Ara versus Mango. And so, the court says this: it is not difficult to arrange a well-conducted parade. The orders are clear. If properly conducted, especially with an independent person looking after the interests of the suspect, the resulting evidence is of great value. But if the parade is badly conducted and the complainant identifies a suspect, the complainant will hardly be able to give reliable evidence of identification in court. Whether that is possible depends on clear evidence of identification. I will not finish the quote. It is the finding of this court that the manner in which the parade was conducted was fraud, and therefore this court cannot find the first accused person guilty of the offense he's been charged with based purely on the evidence of the identification parade per se. The last question is whether this first accused person committed the offense. And I'll pick on issues I raised and that I've not dealt with, so I'll not repeat what I've already dealt with. The first argument of the first accused person is that he can't have committed an offense in 10 minutes, and that is what I want to address now. Person is that he can't have committed an offense in 10 minutes, and that is what I want to address.